my name is Goldman. I'm the director and founder of Goldman Associates. Our firm has a primary focus on family law issues here in Michigan. And today we are continuing our video series designed to educate the public. So please subscribe to our channel. You know, the public gets its education on matters legal from all sorts of sources. Now, this is a particularly great source because it's updated routinely, it's done in real time, it provides as best as we can information that addresses questions that our own viewing audience asks. It's very responsive in that way, so this is a great resource. But a lot of people get their legal direction from TV, from things that they see on YouTube, from things that they see that may not apply to our jurisdiction. That's particularly dangerous. I hear a lot of people ask of a divorce, is my ex obligated to keep me in the lifestyle to which I've become accustomed? That's a great phrase. We hear it on TV all the time. It's a function of Hollywood, you know. And you do see these cases where professional athletes, for example, will have a relationship with someone and the marriage will fall apart after a few years, but meanwhile, this person's been living in a mansion and they've had all their expenses and they have their own expense account for $20,000, $30,000, $40,000 a month. And they want that. That's what they want in alimony. Well, are they entitled to it? Well, the answer is no. You're not entitled to anything. The court can tell you that you may be entitled to certain alimony if you meet certain guidelines. But you have to understand there's no necessary obligation to continue a lifestyle to which someone has become accustomed. I can paint you a picture where it certainly won't happen. I'll give you a perfect example. Two people have a relationship. One of the parties is a very, very high wage earner. They get married. After a year or so, are living together in a beautiful mansion somewhere and spending whatever they want to spend and driving fancy cars and vacations and all that. After a year, the marriage falls apart. The parties get divorced. Is some court going to say, well, you know, these people have lived in a mansion, so therefore for the next 30 years, this person become accustomed to this life, so we're going to continue that? It is very, very unlikely that that would ever happen. More likely than not, the court will say, okay, you had the advantage of a high lifestyle for a year. For the 25 years before that, you had an average lifestyle. You benefited from that. We'll split up whatever marital assets there are, but you're going to go back to your lifestyle. He's going to go back to his lifestyle. That's all there is to it. So the court's not likely to find that, well, just because you got used to a lifestyle, that means the court's going to order it continued. It's very easy to get used to a very lavish lifestyle, particularly one to which one person did not contribute anything. But you have to understand that as the court sees it, the court wants to do what's fair. So in a short-term marriage, the court's not likely to find that it's fair to continue to obligate someone at the same level, even though the whole relationship, which is the underpinnings of that level of support, has fallen apart. Now, if you have any questions about your particular relationship, because it's very fact-specific, reach out and we'll be glad to help you out.